On January 28, 2026, staff from the SEC's Division of Corporate Finance, Investment Management, and Trading and Markets published a joint statement aimed at one thing: forcing the markets to be precise about what exactly is being tokenized. That precision matters in the big scheme because in practice, tokenization is used as a catch-all label for issuers putting their own securities on blockchain rails or intermediaries creating blockchain format entitlements to traditionally held securities or wrappers, or third parties offering synthetic exposure that looks like a token but behaves like a derivative. The statement's core move is to sort these structures into clean categories and then remind everyone that changing a security's format does not change the security's legal status. What follows is our practitioners read the taxonomy, the legal consequences, the frameworks that flow from each branch, and a compliance checklist for anyone building in this space. So first, the SEC's definition of a tokenized security is still a security. The statement defines a tokenized security as a financial instrument that already fits within the federal definition of a security, but is formatted or represented by a crypto asset with ownership records maintained in whole or in part by no one or more crypto networks. So, two intermediate implications. First, format neutrality is the rule. So if stock, debt, or an option or otherwise encumbered security is being put on chain, it doesn't exempt it from registration, disclosure, broker-dealer exchange, clearing, transfer agent, custody, anti-fraud, or any other obligations that apply. Taxonomy is compliant. Many tokenization projects fail not because the project or the product is impossible in a compliant framework, but because the participants can't really describe with legal accuracy what investors actually own. And that would bring me to the next category. So issuer-sponsored tokenized securities, or the issuer rail swap. The staff describes issuer-sponsored tokenization as the issuer or its agent issuing the security in token form and then integrating the distributed ledger technology into the issuer's record keeping so that an on-chain transfer maps onto the transfer from the issuer's perspective on the master security holder file. So for Model A, on-chain master security holder file, or a component of it, in the cleanest version, the blockchain is functioning as the official or at least integrated ownership ledger. So you pair that with an off-chain identity and compliance data framework, for example, linking wallet addresses to names and physical addresses and other required records for KYC. The legal takeaway is that the issuer has not invented a new asset here, right? It has modernized its register, essentially the ledger or the record-keeping component. That is operationally meaningful, but it's not legally unsurprising, right? The Securities Act registration or an exemption still governs offers and sales, and Exchange Act concepts like equity security don't change with the file format. Model B is where you have an off-chain master file and then an on-chain transfer instruction within that token. So the staff also describes a second issuer-sponsored model where the token itself doesn't carry the securities rights and is not integrated into the master file. Instead, the token transfer serves as the mechanism to notify the issuer or the agent to update ownership off-chain. The legal takeaway on this model is not to let the token label confuse the analysis. So you still have a securities transaction, but now you have additional technology, vendor, and control point risk. The quote, same class question. So the statement flags a subtle issuer that issuers often miss, and that's that an issuer can have tokenized and non-tokenized formats of the same security. But if the tokenized instrument is substantially similar in the rights and privileges to the traditional one, then the two may be treated as the same class for certain Exchange Act purposes. Now, as a practical point, your cap table architecture and disclosure controls should be designed so that if the SEC were to look through the format to the substance, it checks out because the staff is essentially telling you through this statement that it will. Category 2, so third-party sponsored tokenized securities, where risk effectively migrates to the intermediary. So where an unaffiliated third party tokenizes someone else's security, and then the staff emphasizes that holders may have materially different rights than holders of the underlying security and may face additional intermediary risk, right? Including bankruptcy risk, essentially risks that this third party isn't gonna do what they said that they were gonna do, or they're gonna do something bad. The underlying security holder might not bear the same types of risks as they would otherwise. So the SEC then breaks this down into 2 observed models. The first is the custodial tokenized security model. So these are tokenized security entitlements. Here, the third-party holder holds the underlying security in custody and issues a token that represents an interest through a security entitlement structure. The SEC staff's December 11, 2025 no action letter to DTC essentially frames this around tokenized entitlements being a pathway for bringing blockchain record keeping into existing market structure. And the legal takeaway is that you're not tokenizing the issuer here, you're tokenizing the intermediary's entitlement ledger, which is a very different thing technically and kind of pulls you directly into the custody clearing and customer protection framework. The next model is synthetic tokenized securities. So linked securities, essentially, and security-based swaps. So the synthetic branch is where the market structure and the derivatives law start doing some real work. The staff effectively describes 2 synthetic forms. Linked securities, so the third party issues its own security, providing exposure to the reference security, but it confers no rights in the reference issuer, the actual underlying. The other is a security-based swap. So that is effectively a token that functions as a security-based swap with the familiar constraints on who can be offered the instrument absent registration and where it can trade. Now, on this point, the legal takeaway is that if you are selling exposure, right, and you're not selling ownership, then you need to expect the SEC and counterparty counsel to treat the instrument like a structured product or a swap, and not like a simple token wrapper. So what market participants should do next in terms of a working checklist is don't treat this or any SEC statement that's not an actual rule as a rule. It's not a rule. It doesn't create new legal obligations, but it is an important roadmap from a regulatory perspective in most practical sense, right? The SEC wants to know what the market is doing and wants you to know how they're thinking about that and how they're analyzing market activities so that you can be prepared. And here's the checklist that we would run internally before anyone ships a tokenized securities product in general. One would be start with the rights, not the rails. So what are the legal rights that the token holder actually has? So do they get dividends? Do they get to vote? Redemption rights, information rights, liquidation preferences, remedies. The second question would be, do those rights run against the issuer, a custodian, or a special purpose vehicle? Let's think about the identification of the ledger of record. Is the master security holder file on chain, or is it off chain, or is it a hybrid? Is it maintained on dual tracks? Who is the transfer agent or the functional equivalent? And how are those reversals, errors, liens, and transfer restrictions, if relevant, being implemented into that system? The next piece would be, let's place this product, let's place what you've built, this token, into the SEC's taxonomy. So issuer sponsored or integrated ledger, off-chain master file, token as a transfer mechanism. Is it a third-party custodial entitlement? Is there a third-party synthetic features? Is it a linked security? Is it a third-party synthetic security-based swap? And then I would map the regulatory perimeter. So think about Securities Act registration. Make sure you have a securities lawyer look at that, look at the exemption analysis or registration analysis for offers and sales, regardless of format. I would have someone who specializes in trading and markets types of issues and implications for exchanges, ATS, broker-dealer activity, and related rule sets depending on where and how secondary trading is going to occur. If derivatives economics are present, make sure you run the security-based swap test early. Don't wait until you're 5 miles down the road and you've already invested a lot of money in a plan that might have to be tweaked by legal. The next would be that disclosures should track the actual risk transfer. So if the token holder is exposed to intermediary insolvency risk or operational risk or different remedy packages than the underlying security holder, that needs to be drafted, right? It needs to be contemplated and it needs to be included. So the staff's emphasis on third-party risk is it's not subtle, and it's something that counsel in-house and outside needs to be aware of. And then the larger signal is that the SEC is working towards standardizing this idea of tokenization around existing market infrastructure, right? If you kind of read in the context, right, the January 28 statement pairs with the Commission's growing willingness to discuss tokenization as a modernization of securities infrastructure rather than as a separate parallel system. This is a good thing for market participants in my view. The DTC tokenized entitlements pilot is kind of the clearest example of this. This is also consistent with Commissioner Hester Peirce's repeated theme, right? That tokenization can be accomplished, it can be innovative without being legally magical, right? And that hard work is involved, but that we can fit this new distribution and trading model into the investor protection architecture that is so important and what makes America a great place to invest. So thank you so much. My name is Braeden Anderson. I'm a partner at Gesmer Updegrove. If you have any questions, you're building something, you're thinking about what to do next, I know that this video was deep and dense and some of it may have been confusing. That's not a problem if it was. Reach out to me. This isn't meant to be legal advice. We're talking about some things at a high level that might be kind of confusing without context. So if you do find any of this interesting and you have some questions, feel free to reach out to me and I'd love to learn more about what you're doing and how I can help. That's all for now. See ya.